Okay, why don't we get started? I'd like to be prompt here, and it's 9:31. Does that sound good to you, Monica?
Yes, it does.
Okay,
Good
good
morning.
morning, everyone. Welcome, welcome, welcome. My name's John Bro. I am the Vice President of MLS for the Rhode Island Association of Realtors and Statewide MLS. I am joined, as always, by my partner in crime, Monica Staff, General Counsel and VP of Policy for RIAR and Statewide. Morning, Monica.
Nancy, good morning, John. How are
Good to
you?
see you. I know your title's getting too long. We're gonna have to,
I know we're gonna have to put it all across the screen. So
right. So good morning. So what are we here to talk about today? Well, first let's talk rules of the road, I guess. This isn't your first rodeo, no doubt, in attending a webinar, and it's pretty simple. We have a Q&A box. There's no chat. There is a Q&A. If you have questions, type them in, and you can upvote questions if you see something you like and you want to sort of click it up and send it up there. So uh, don't bother raising your hand. We won't be unmuting anyone or anything like that. And we'll take questions as we go along. We'll leave time at the end of the webinar for questions, but we like to we like to grab them as they come in, right, Monica?
we sure do. And actually, I see some people trying to raise their hands.
Yeah,
If you're looking for the Q&A on, I don't know about your computers, on mine you have to click more. So if you're at the bottom or the top of your screen, and on mine I see participants, I see chat, and then I had to click a button more to find the Q&A. So if
yeah,
you're
they may
raising your
see
hands
it
for that reason.
because we're presenters. We may have more options than they do, so hopefully it's just right
Oh,
there in the
that's a
without having
good
to click
point.
more. So I don't know. Maybe somebody could type a question right now and just we can give a test run.
And we're
Uh,
also recording this
well, there we go.
in case anyone has questions
Test.
about
Good
that.
job, Kimberly. Woo! All right. Appreciate it. Good
Yay.
morning, everyone. Okay. All right. All right. Enough with the test. Sorry. Thank you.
Okay.
Okay. So, as you know, anyone who's attended these before, Monica and I like a sort of uh, informal slash formal approach. We like to have a lot of interaction here and a discussion. Again, by all means, type your questions in as we move along. The topic du jour is related to MLS rules and a change regarding listing properties before the seller has legal title. And so we'll talk a little bit about this, or we're going to talk a lot about this. It's greater than just wholesaling. A lot of there's a wholesaling is a buzzword, and a lot of people are talking about that, and that's sort of one component of this. But we're really talking about any situation where a quote unquote seller is listing a property, but they're not the legal title holder. They have what we are calling equitable title. So we've sort of deemed these things, and actually that's a perfect opportunity for me to switch slides here. What we're calling these things for our perspective, are equity slash assignment listings. And what you see here on the screen is the actual definition that we are incorporating into the MLS rules and regs, which is a form of listing submitted to the service where the seller holds an interest in the property, but does not yet hold legal title to the listed property. So, Monica, let's start off with a question for you. How does one find themselves in a situation where they have equitable title or an assignment listing?
I'm glad you asked that, John. Now,
Yes.
actually,
How
before
about
I
that?
answer that, I've got one more rule of the road, which is this is an hour-long webinar, so we
Oh,
will end
yes.
at 10:30. Okay, so I hope we've anticipated all the questions that people trying to raise their hands were trying to ask us. Okay, so this is so an equitable title. That would be once a buyer and seller sign a purchase and sales agreement for the property. At that point, the buyer has equitable title. So what that means is, or actually what it doesn't mean, is that the buyer can't start moving their things into the property. They can't start painting it. They can't make repairs. They can't do anything like that. Their name isn't on a deed yet because there hasn't had a closing. That does mean that they have a partial ownership interest in the property, meaning, and that means that the seller can't just turn around and sell it to somebody else. They're under contract to this buyer. And then when they
And,
close, that's when they get the legal title.
and so the ability, and we'll talk about, why somebody would sell that in just the next slide. But so that title comes, as you said, from being a buyer in a P&S. And is that now I'm going to ask you as a lawyer, is that language that is addressed specifically in the PNS where they're somehow granted this thing, or is it just by virtue of the fact that they are the buyer of the PNS that by default gives them an equitable interest?
It is by virtue of case law. So there's nothing
Okay.
in the law that specifically says that. There are sections of the law that give the buyer a right to record a purchase and sales agreement, but I'll stay out of those rabbit holes. I get enough into the weeds as it is.
Yeah,
So
yeah, yeah. Okay, perfect. Yeah, well, I just thought I'd ask that question.
no,
So,
no, it's a
uh,
good question. My answer's
so
too long, so
no, no, it's good. Well, you're a lawyer. That's what you do.
yes, it is.
So, all right. So now this sort of just goes right logically into the next question of now I'm the buyer, I'm at PNS, the scenarios in which I might think about selling that interest prior to taking legal title. And so you see on the screen, some, I guess, common scenarios where that might happen. Monica, maybe can you just address each one of these sort of if you don't mind?
Sure. I do not mind one bit, John.
Thank you. That's why
So,
you're here.
right. I get to be the sidekick. Anyway,
Yeah,
by the way, you should all be lucky we're not doing this in person because John and I both have colds. So
I
we'd be
know.
sneezing over you and each other right now. So, so part of it you might think, well, as far as why would you sell the equity interest? Part of the question is, well, why don't you just wait till closing? So you've got the equitable interest and you've got the legal title both. Some of the examples that John has included here, someone's flipping a property. Well, you might have someone who, a true flipper that's doing, they have a team of people who, as soon as they take legal title, they're going to do work on the property. They might paint it. I mean, it might be more cosmetic. It might be some significant work on the property, but they're sinking those costs in as soon as they close. So they'd like to get a buyer lined up and get a head start on figuring out who they're going to sell it to. So that's one reason why someone may not want to wait till closing. Another is new construction. Some of you have worked with new construction with builders. They may have a parcel of land under contract, but they can't start the construction until they close and they get all the permits and everything all set. So they want to get a head start on marketing new construction to the buyer, particularly if they want to do like a custom build or something like that. They'd rather get someone lined up now rather than because they're paying they'll be paying financing charges, whatever, for the
Mhm.
property. So they want to get that head start. And then finally, the wholesaling. So the wholesaling, and one thing, John, I think you've got a separate slide of this, if I'm not mistaken.
Yes.
Um,
Yep.
Make sure that we all know what we're talking about with wholesaling. So here's an example of one. And I'll use some numbers from my head anyway. So when you think of the term wholesaling, that refers to it doesn't have to be contacting an owner of a distressed property, but it often is. So a wholesaler reaches out to somebody and they offer to buy their property for below market value. So let's say a wholesaler approaches someone for $250,000. They sign a purchase and sales agreement for that amount. But before the closing, the wholesaler wants to assign his interest or her interest to someone else. So basically someone else would close on the property instead of the wholesaler. So in this example, the wholesaler they might start marketing their property for the property they have under contract. They might want to market that for say $300,000, even though the original price from the seller is 250. And then once they find that buyer, they keep the difference. That buyer steps into their shoes and takes over the purchase and sales agreement. So they meet all the deadlines like the closing date, if there are any financing contingencies, all of that. So that in a nutshell is what for purposes of these MLS rules, what we're considering wholesaling.
So to that question, we actually have a question, I guess sort of it relates to this, where someone asked, can the buyer assign the PNS to a different buyer? So is that essentially what's happening in wholesaling? They're assigning the PNS?
Yes. Yes. And the law just in general, the presumption in the law is that contracts are assignable unless you specifically state in the contract that they're not. So, and even though this is an MLS program, I'll mention the Rhode Island Association of Realtors purchase and sales agreement. Those purchase and sales agreements by default are assignable. So if you are working with a seller who does not want a contract to be assigned, that's something you would want to add in additional provisions that this contract cannot be assigned. without
Okay.
the seller's written permission.
Excellent. Okay, great. And we'll talk a little bit more about wholesaling a little bit later on in terms of some of the other issues around it. Again, we're not taking a position in any particular business
Right.
models or evaluating the merits of doing business this way. We're just simply acknowledging that these things exist out there. And in the context of an MLS, how can we accommodate the needs of our subscribers, but also protect our subscribers and consumers. And so this is why have made these changes. And with that, let me just sort of go into, I guess, a little bit of how we got here, right?
Oh, John, should I
Yep.
jump in a couple of questions
Oh
first,
yeah,
I
yeah. All
guess?
right, sure.
Okay, so one of them, I think I just gave the example. I hope. If I didn't, you can
Yeah.
post the question again. Um, and then there's a question about is the assignment law, is that state or federal law? State is the default is state law. So it just there's nothing that any contract can be assigned unless there's a specific law that says it can't, or unless the parties this can't be assigned, either at all or without someone else's. You might see with assignments, something like a personal services contract, where it's critical that you work with that particular person. Those are some of the things that wouldn't be assignable. But with the purchase and sales agreement, as long as someone can step into your shoes, if I'm the buyer buying from John, as long as I find someone who can step into my shoes, meet all the dates, purchase for the original agreed upon purchase price, then the assignment's met. And I did see someone in here, and then John, I know we want to get through other slides, so I won't
No,
do
no, no.
this
These are
now.
good slide. These are good questions we should address right now. So,
Okay, all
uh,
right. Yeah,
yeah,
I
yeah,
mean, they really are good questions.
yeah,
So,
yeah.
someone
And
had
there are no
had
bad
some,
questions, right? There are no bad questions. But yeah,
I
no, these are
agree. The
perfectly
unasked
timed
question's the only
questions.
bad one.
So
Yeah, no.
let's sit here for a bit and go through some of these.
There was one I think you clicked already, but there's one about saying the person's experience. Oh, here it is. I have not seen where the dates of the original contract are honored. Can you speak to that?
Yeah.
Yeah, and that is one of the downsides. As John said, we're not trying to attack a specific business model. We're trying to kind of be neutral on it for purposes of multiple listing service. But yeah, that is actually can be a real danger with some of the wholesaling agreements that the original seller thinks they're approached by someone who might tell them we're going to buy your property for cash. The seller might be willing, even if whether they know or don't know it's below market value, they may be perfectly willing to agree to that, but they're thinking they're going to close in a week or two. Well, if the wholesaler doesn't already have someone lined up to assign the interest to, that week or two could turn into lots of extensions time down the road. Actually, Connecticut just has a new law going into effect next year that says that any kind of wholesaling contract must close within 90 days to at least help a situation like that.
So there was one question. So if the assignment buyer can't meet the original contract dates and terms, then the seller uh, can't refuse extensions if the buyer can't close uh, the buyer's
Rise
EMD is at
deposit.
risk. Yeah. So earnest money
Yes.
deposit, right? So do you want to
Yes,
address
that's
that?
correct.
Yeah. Okay. Um, properties marketed to MLS. All right. So we'll answer these next two as slides. So I mean, there was something where somebody asked about examples of pricing. I mean, you did give prices, so it's a scenario, but I mean, wholesaling itself. I mean, why do they call it wholesaling, Monica? Is it because it's always the case where uh, the wholesaler is buying it at a price and selling it for more, or is it wholesaling it because they're just doing it on a wide spread where they're just doing multiple properties? Where does the term wholesaling actually come from?
You got me, but I mean, my best guess is that it's like kind of like a middleman, a middle person.
Is that
Do
what
you know
it?
what I mean?
Yeah.
Like if
Okay.
you look at the retail industry,
Yeah.
manufacturer, you've got a wholesaler who's placing it with different retailers. Then you've got the retail
Yeah.
outlets. So I think it's
So that's
probably
the
a spin
market
of
is to try to get it, like you say here, below market value, ideally, and then sell it, uh, for a profit, obviously, right? So,
right.
okay. All right, good. So to sort of segue to how we got and what we're going to allow with MLS. So, sort of historically, Well, the rules and regs have been silent on this issue previously. They've never really talked about, listing properties, or that the seller had to be the legal title holder, or sort of listing these equity listings. We've had uh, properties where you'll see language in there where it, generally it's sort of like the flip situations, basically, where the buyer wants to buy it, but they want to relist it because they want to just get a jump start, right? They're going to whatever improve it, flip it. Um, and so we've allowed it with this caveat that they have to disclose subject to seller taking title, right? And there haven't been a lot of them, but that sort of has worked over the years. But in more recent scenarios, well, especially with wholesaling, right? The seller is never taking title, right? And so that was sort of the complaint. Well, in these models, so this sort of exception to the rule didn't quite fit. And so we decided we really needed to do a deeper dive on this and say, okay, what should be permitted and under what circumstances, and how should we then modify the rules to address that? Right. You saw in the first slide, we modified the rules by giving a definition to what we were talking about, right? Equity assignment listings. But we had to do further evaluation of, when is it okay? When is it not okay to put a listing in the MLS, essentially? And so the questions we had to ask ourselves are, what are the risks for MLS, for you folks, our participants and subscribers, and for buyers and sellers in allowing equitable listings in the MLS? What types of listings, if any, should we permit? And should any disclosure or consent forms be required from the actual legal owner of the property to be listed in the MLS? So these are sort of, these were the things that we dug into, and really what led us to where we are today, which was really, it really came down to whatever the business model or the reason, it really came down to two fundamental concepts. And that one, that there needs to be authorization, not the authorization of the buyer slash seller too, but the legal owner of the property really should authorize the assignment sale in the MLS. I mean, if a property is showing up on the MLS, the legal title holder has no idea. People are showing up on the property, or they're getting, hey, they see your house is on the market, all these things, and they're completely oblivious to this. They really, in fairness to our customers and to consumers, that there needs to be some authorization to allow that. Now, this is a threshold for MLS listing submission. This is not a threshold for legally being able to do this in the state of Rhode Island, right? You don't need the legal owner's permission, for example, in wholesaling, correct, or in flipping, or any of these things. To market the property outside of MLS, you need this to list the property in MLS, right?
And John, if I could just add one
Yes.
quick thing to that. So I saw a question in the Q&A that somebody had asked whether these are our rules or whether these are laws. I think just John's already been addressing this, but just to make sure everyone understands. So these are MLS rules that we have adopted. Our leadership has adopted to protect the integrity of the database, the users of MLS. Wholesaling is a legal practice under state law. So, okay, that's
And
it.
again, this is broader than just wholesaling, right? I mean, that's one of the
It is.
things that we're talking about. But again, we're also talking about new construction. We're talking about flips, et cetera, right? So
Even
whatever the
foreclosures
scenario
too.
is, go ahead.
Oh, I'm
Sorry, Mark.
sorry, John. Even foreclosures too. Sometimes we've had
Yeah.
some of our MLS participants who either they or a client are purchasing a property at a foreclosure auction prior to closing. They already are planning to market it, so to flip it to someone else. So they want to get that head start on doing that too.
Which again, we're saying you can market it all you want. It just can't go into the MLS unless the legal owner of the property has authorized that listing in MLS. And this is in more detail. It should this authorization should include the seller's agreement to the marketing of the property, allowing access to the property, and acknowledgement of the legal obligation to provide a seller's disclosure. That was discussed in some great detail, but Monica, I might have to defer to you, or I don't know if you're prepared to answer the seller disclosure. But I think some of the concern was who was obligated to provide the seller's disclosure in these equitable listings. Is it seller number two, or is it seller number one? Can you speak to that at all?
Yeah, that's a dicey one.
Yeah, I
I
think
don't
we
know that I
sort
have
of,
a great answer because,
yeah,
I mean, if I were the buyer of, if I were buying from the person with equitable title, I mean, legally, someone's responsible for giving me disclosures. I would go to the disclosure of the person who holds legal title because the other person, if they're not flipping the property, they're assigning the interest to me, so they're not really the seller. I probably just made
someone
this
here
more
says it's
confused.
seller number one, they think is
Yeah, seller
responsible.
number one's yes.
Yeah,
Yes.
so that could, yeah. So you folks are the experts in this. I have no
Yes,
idea.
you
So,
are.
but it's something obviously. I mean, it's something to take into consideration, right? Because somebody has to give disclosure to the buyer, correct?
Yes.
Okay. All right. So authorization. So like as I said, in order for these properties to be listed in the MLS, there were two concepts. The first being this authorization. The second is disclosure. Disclosure to the seller themselves, right? The owner. They need so which comes sort of falls back into the first bullet about authorization, but that's so that the seller is aware that this is happening. But also to buyers. So that to an MLS, that means also to cooperating brokers, prospective purchasers, so that they know, this, as you saw in the previous slide, we had some language, subject to seller taking title, but there needs to be some disclosure so that when people are looking at this listing, they know that it's an assignment sale. And we'll go into some detail now. So we've addressed these two uh, pillars, we'll say, of the listing in MLS. So how do we get there? Are there some questions you think we need to address here, Monica, before we move on?
I'm getting a couple of questions about recording again. So
It is
this,
being recorded.
yes.
Uh, I can also drop in the chat a PDF. I'll do that afterwards. I don't want to do that now on the slides on the screen.
Yeah.
But I have this whole thing as a PDF, by the way, and I'll drop that in the chat near the end of the session, so that you can grab that as well. Uh,
Yep. And then, John, there was a question about the third bullet.
which
Someone's
I think that
confused
was on
by
the
the,
previous slide, though, I think, right?
oh, was it?
This,
Okay.
oh, maybe this is a typo in here. Should any disclosures or consent forms be required from the legal owner for the property? Yeah, to be listed. So it's a typo. So you're right. Didn't make sense. Apologies. Thanks. Thanks for catching my typo. Okay. Let's move on.
Oh, John, there is one more question that we
No,
can,
go
we can
ahead.
hold up. We
You
can
hit
hold
them.
the others.
Yeah, you don't have to. Keep going.
Okay. If someone wanted to know if there will be a one pager regarding these changes.
A
So
one
will we do
pager.
anything? Yeah,
Yeah,
like
well, good question. I'll say yes. Yeah, we will do because we need to make a formal announcement because there's still some system changes that need to go into place, and we'll have to actually have an effective date. So this actually isn't effective yet, just because we can't accommodate some of these things yet in the MLS. So you're getting sort of a pre uh, pre notice of the changes coming up. So we will do an announcement. We'll make it a one pager and with maybe some screenshots and such, so people know how to do what it is they need to do.
one more, John,
Um,
and then we can. Then I don't want to interrupt your
Go
flow.
ahead.
We can go back to some of these later. Will there be any changes to our listing contracts regarding this topic?
I don't believe so. I don't think there needs to be right. This isn't really
Yeah, we don't.
contemplated.
I don't see any.
Yeah.
No.
No. Good. Okay. So, however, there will be a new form. Woo! Everybody loves their forms, right? So we established the two pillars, right? Authorization. How do we get to authorization? Well, we've made it easy here, and I'm going to stop sharing this screen and open up the form that you will need to use uh, when submitting a listing, one of these listings. And so it's on the screen now. Can you see that okay? I can zoom in a little bit more. So it's an
Yes.
equitable interest or assignment listing authorization form that the listing broker of the equitable listing will need to get the actual title holder of the property to sign. Monica, do you want to talk a little bit more detail about this?
Yes. Yep, yep. So part of it, you just want to make sure that the seller, that we'll say seller, is seller number one easier to use? I think you said some people in the Q&A were saying that.
Yeah,
So
seller in this
basically
case is seller one, and buyer is in this is really seller two, right?
yeah, so in the first section, you're basic in the assignment or sale, you're just letting seller number one know that the buyer wants to get a head start on marketing and transfer the equitable interest, um, market that. Then in the marketing property, they're just letting them know that they may be doing for sale signs or putting this in multiple listing service. It also lets them know that the price might be the same or a different price than what the buyer agreed to pay seller number one. So you don't have to disclose what that price differential would be if you're the buyer, um, but it is something that you're letting the seller know. And frankly, just to say, this is something that's triggered legislation and new laws in a number of states. And we'll get to that. We're looking at some filing something similar in Rhode Island. But for the most part, like nothing requires anyone to disclose what that different amount is, what they're marketing the property for, if it's a higher amount or a different amount. But it's just letting them know, like, hey, you should be aware of this. Um, and then access to the property. This is actually an issue we've seen several times in multiple listing service, where you want the seller number one to authorize the buyer slash seller number two to be able to show the property, or maybe you don't, but it's giving the seller that option. But what we've seen a couple of two, three times in MLS, where the buyer slash seller number two was actually one got access to, or at least the allegations were they got access to a lockbox code, and they were actually showing buyers that they wanted to assign their interest to. They're showing buyers the property without the seller's knowledge. Now, the different sides to every story, but that was something that we kind of went, oh my goodness, that's a little
Yeah,
scary.
yeah,
And just as
right,
John said in the very beginning about, seller number one should know if people are going to be traipsing all over their property and be able
right.
to have some input into whether that happens or not.
And again, this is a threshold for listing in the MLS, not for your legal right to market this property outside of the MLS, right? You don't need this form, I guess, currently under Rhode Island law to be able to sell one of these, but you do need this to list it in the MLS. Also, you see this paragraph here for the disclosures, which does support one of the comments earlier that it ultimately is the seller number one's responsibility, right, for that disclosure to be provided to any buyer. So that's an important disclosure because in any situation where the property is being, the equitable listing is being sold, this if the seller's not even aware this is happening, how can they fulfill ultimately this obligation to disclose information? They're not even aware this is happening, right?
Right. And as a lot of people pointed out, that the buyer slash seller number two, like they don't know anything about the property. They just signed a purchase and sales
Right,
agreement for it.
right.
And
Well,
John, I
they may
did
or may
see,
not,
yeah, that's true. They
depends.
may or may not.
Remember,
I did
yeah,
see
this
a
is broader than
question.
just wholesaling, right? This is any number of scenarios. So,
It
so
is.
one of the
They've,
questions is,
yeah,
can you confirm when this goes into effect? I don't have a date yet, so I can't confirm yet.
but we're looking at,
Yeah, it should be soon. It's just really a matter of when the system changes. They're on uh, our staging server, but before we go live, we just you need to make sure everything works okay, and then we'll just need to get some notice out to folks and let you know. So shouldn't be too much longer. Uh,
John, I
is
saw a
this
couple of, oh, go ahead. You go ahead.
is this new form to be presented along with the P&S or during the inspection period? I guess it can be in any time, right? I mean, that's a good question. I mean, there's no rule, right? But in my way of thinking, if I'm the buyer and I intend on having a right to resell this and I want it in the MLS, then and I probably wouldn't sign a PNS unless I knew I had this signed as well, right? But again, you can still legally sell it. You just can't list it in the MLS without this form signed. So it's as early as the signing of the PNS and at any point after that, right?
Yep. I mean, I wouldn't say that the buyer who's seller number two, I wouldn't say that they would have to No, never mind. Sorry. Cold
Yeah.
medicine kicking in. Never mind.
Yeah. Well, I mean,
Taking it.
again, it's a new form. I mean, again, if it's a, and by the way, I don't know that we're seeing many of these in the MLS anyway, so I don't even know that many people that are sort of doing these things really care about getting it in the MLS. And so and realistically, I don't know how many of them would be interested in having a seller sign this, or how many sellers are even going to sign this thing. But again, this is the threshold for listing in the MLS. So if it's critical for somebody in this scenario to get the property in the MLS, then I think they're going to want to have this discussion as early as possible to make sure that the title holder is okay with it. Otherwise, then
Yes.
that impacts their ability to market in MLS. So, um, right? I think we've
I
answered
think,
that.
John, I think I know what I was going to say. So, I think when you mentioned the purchase and sales agreement, I think that's what threw me about the timing of it. Because I was thinking of buyer number two and their purchase and sales agreement, which it doesn't have anything to do with. Yeah, this one is this particular form. I mean, you just want to have it once at any point that the buyer wants to start marketing this before the closing. It can't go into MLS
Yeah.
unless the seller number one has signed this.
And let's just sort of, point out, I mean, this isn't, MLS and RAI are getting together and thinking of some like new business model or some new great way to go out. You guys should start doing this thing or any, really what we're doing is just reacting to situations that are already happening out there, right? And so that these things have been out there and exist. And again, it's not just wholesaling, it's other scenarios. And while, as Monica said, we're neutral on it. Uh, to the extent that these may appear in the MLS, what threshold should be met? What are the requirements for listing this into the MLS? So it's nobody has to do any of these things. It's quite possible that you may never even come across this situation. But if the situation does present itself, here are the guidelines in which you would need to follow.
Yes.
Okay. Any more questions related to the form? Should we linger on this form a little bit longer or?
Well, I think there's not on the form, but there was one on I think on a couple of slides before that. You don't have to jump back, John, but the question was just I think people were still a little confused about how a wholesaler is making money out of that transaction. So I'll just give a
I
really
don't
quick
know.
example. No, I'll give a
That's
really
sort of
quick
outside the
example.
scope of this, right? I mean, but that's fine.
It
We
is
can
that'll
talk about
creep
it.
into the legislative part of it, the
Yeah,
legal
yeah, yeah,
part of
yeah. We'll
it.
be talking
So
about that more a little bit later, but go ahead.
we will. So just as a quick, so the example I was giving before, so you've got seller number one, legal title owner to the property. They signed a purchase and sales agreement with the buyer. In that purchase and sales agreement, they agreed to $250,000 is the purchase price. Then, assuming this form is signed and all of that, that buyer then becomes seller number two. They list the property in multiple listing service, let's say, and they list it for $300,000 instead of 250. Um, once they find if the listing broker and they find a buyer, that buyer steps into the shoes of um, the new buyer steps into the shoes of the wholesaler. So they're going to complete the contract. Now they're buying at the original 250,000 is what's going to seller number one. What's going to the wholesaler is the $50,000 markup. So seller number one doesn't know about any of this. All they know is they're getting the $250,000 that someone promised to pay them on a certain date. The wholesaler is keeping the difference, the markup in the property, so that $50,000 difference.
Okay, let me take over while you.
Thank you. I have
This
a
is the thing we
hacking
have a
fit.
cold.
Yeah.
So here's a question. So how will this impact corporate clients who are listing assets prior to foreclosure deeds being on record? I mean, I guess the impact would be is they need to get the seller to sign that form if they want to list it in the MLS. That's so the seller's uh, I mean, the seller's willingness to sign a form like that in a foreclosure situation may be tough, but I don't. Are these listings currently? I mean, this again, we're talking about their legal right to be able to sell outside, which they're doing. But are many of these listings actually in the MLS currently, or not? I don't know that they are, but to answer that question specifically, it will impact them because they will need to get this equitable interest assignment form signed.
And that issue of recording the deeds too, like foreclosure deeds, that's been kind of an ongoing issue about as things are transferred from different, international or international lenders to different holding divisions and things like that. There's been a lag for quite a while in getting those deeds recorded. So I don't know that we can solve that one in MLS, but
Oops. I'm trying to scroll through the Q&A and I'm scrolling through my slides. Okay, so it just so related to that form, so the seller signs the form and then that form must be attached to the listing. So much like what happens now with coming soon or deferred showings, when you take a coming soon listing, you attach the form to the listing as a supplement. And so we'll be adding a new supplement type. That's one of the system changes we're waiting on, whereby you'll see an option for this and you can attach it. We're also making a change to allow for privacy settings for certain forms because right now any supplement attached to the listing is visible by anybody in the MLS, and really things like this should be visible just to the listing office and to the MLS. It's an MLS rules enforcement issue, so you should be able to see it for your listings, and we should be able to see that the form is there, but. Really, the forms don't need to be visible to all subscribers of the MLS. It's not really their concern. Um, I don't have screenshots on that, but that's something it's pretty simple, and we'll include that in the instructions, the one pager as we move forward. So the other part, we have authorization. So now disclosure. Well, what is disclosure going to look like? Well, we've made it really easy. There's going to be this equity assignment yes, no field, and you don't have to fill it out. It's not a required field. Well, let me rephrase that. It's not a required field, so don't feel like you're going to have to answer this question for every listing you answer. However, if you have an equity assignment listing, then you are required to answer this question with a yes. And as it says here on the screen, we've made it real easy. So by selecting yes, there's the language in blue will just be added to the very bottom of your public remarks. The seller has a contractual interest in this property, but is not the legal owner. So we've made it easy because a lot of times people are like, well, what should I say? What's the language? Whatever. This is what it is right here. And so a screenshot of what it would look like on your listing is this here, the highlighted part at the very bottom, where that's what that disclosure would be, so that it goes out so that the people within Matrix can see it. You can this will be a field you can search by. You'll see the equity assignment field, but you can also see it in the remarks as well. And that this will go out to IDX sites, etc. So that is that. Maybe we should pause and you're going to take it away here and talk a little bit more detail about wholesaling, but let's just look at a few more questions before we go down that. We got about 20
sure.
minutes.
Yes.
I think a lot of these may be sort of related to this wholesaling anyway.
That's what I'm kind of thinking too. Yeah, I mean, there's
Yeah,
one,
yeah,
someone had mentioned that he'd seen properties marketed in MLS in Connecticut. Yeah, I
yep,
mean,
saw
we've
that.
definitely seen them here. Some people have asked us, well, once the rules change, go into effect, are people are just going to not list, or wholesalers in particular, does that mean they're just not going to list in MLS? They may not, but builders, people with foreclosures, investors, other types of investors who want to do flippers, who might want to do work on the property first. Yeah, I think there could still be an interest in their doing it. That's really up to you and your client and whether they're willing to go along with the regulations. But we see it as a consumer protection issue, multiple listing service.
Yep. I accidentally uh, hit answer live on a question before you answer it.
I've
But
done that before too.
someone wanted to make sure we were clear in that the disclosure, what we're saying is, yes, in fact, it is the legal title holder that is ultimately responsible for the seller's disclosure.
Yes, and I might have tripped over myself in the beginning. I might have muddled through that answer initially, but yes, it
Here's a
is
question.
with an assignment. With an assignment, it is If the
Yeah.
title
Okay.
is going
Yep.
from the legal title owner with an assignment, the legal title owner is the one who's actually giving title. That's whose name is going to be on the deed if there's an assignment. So yeah, they're the ones who are doing disclosures. If there's something else, if you're going to have a double closing or something like that, or the example I gave with new construction where you've got a builder who has land under contract who wants to get a head start on marketing, and so they're actually going to take title to the land. Then after that closing, they will transfer it to someone else. And new construction is exempt from disclosures anyway, so that's a whole separate issue, but land is not
Okay.
exempt.
So here's a there's a question related to the form. Why doesn't the form grant seller one the ability to say yes, you can put it in MLS, but also no, you can't show the property? It's true that form is sort of written as an all or nothing, right? That it includes the ability to show. I suppose they could amend. There's really no blank lines in there, but they could strike that language out or amend it if they wanted to, right? I mean, they're prohibited from doing that, are they?
But if it can't be shown though, how can it go into MLS?
Well, that's a good point.
Everything else has to be.
That's true. Yeah, there is that, right? Properties have to be available for showings in the MLS, right? Here you are schooling me on MLS rules, Monica. How dare you? Good.
Okay, I'm only a legal counsel, right? So,
Yeah, whatever.
okay.
Uh, and there was a question about what actual language should be used if the seller doesn't want to allow transfer. And so you had mentioned in the PNS that it's assignable by default unless there's language in like additional provisions, but you don't really have any specific language, right? That
Well, sure. It's really just a sentence. This contract is not assignable. Or you could say this contract is not assignable without the written permission of both parties. So, but feel free to contact me separately too if anyone has your own idea and want to discuss specific language. But it's really just something that could be that simple, just a sentence saying it's not assignable or that the buyer can't assign it, whatever you want to do.
Here's a question: can MLS be held liable in courts if courts rule against this? I mean, I don't know. I mean, I, I don't really know what they're ruling against. I mean, I guess what the allowing of wholesaling, or I mean, it's all about disclosure and authorization, I guess, is what we've tried to do to protect ourselves and you folks, right? So that if all the parties are agreeing to these terms before it can be listed in the MLS, then there's consent from all the parties involved, right? I mean, if the courts decide that this is not a legal way of doing business, then we would, of course, repeal the ability to list these things in the MLS, right? If they're not legal. But it would still apply to flips and, other scenarios, right? And so maybe that's a good segue to sort of talk about wholesaling specifically, Monica, and
Yeah, and then
what
we'll get
RYR
and
is looking at on that front.
sure, and we'll make sure. So because of and actually I sit on the National Association of Realtors Risk Management Committee, so they've got representation from all the states. This whole issue of wholesaling, and I know John's taken great care to remind us the changes to the MLS rules do not just apply to wholesaling. They apply to other types of business models and purchases and sales. But at any rate, this is on this whole issue though of wholesaling and assignments for many of the reasons people put in the comments. It's on the radar screen of regulators across the country. We now have more than 10 states have adopted legislation. One initially just banned wholesaling altogether. We're not looking to do that in Rhode Island. We're looking to make sure that consumers understand what they're getting into. So very similar to what John's been explaining with the MLS rules and regulations. We just want to make sure that if someone wants to market real estate before they have legal title to it, what protections do you have for consumers? We've looked at laws from a number of states, and by we, I'm talking about the Rhode Island Association of Realtors Government Affairs Committee. Um, and let me just see, John, I think I had a couple more slides on that if you want to go into the next. Yep. So part of it would be, and like you said, this will be very similar to what you're seeing, what John just talked about with the MLS rules, having the wholesaler disclose in writing to the legal title owner that they're planning to market and assign their interest before the closing. And then I'll get to, we saw some comments in chat about people who've had experiences of delays, things extending where a seller legal title owner thought the closing would be, in a week or two. And then it turns out to be months and months of delays because the wholesaler hasn't found someone to assign their interest to at the price that the markup they want to sell their interest for. So the RIAR legislation would create a 3-day right of rescission for sellers. So in other words, the wholesaler would have to give this written disclosure to the sellers, just telling them what's going on, the legal title owner. And if they don't do it, the seller would have a right to back out of the contract. And it's similar to what you see with buyers with mortgages. You can get all the way to the closing, and the buyer still has time to back out. It would be a total mess, not a great idea, but if they suddenly felt that something wasn't appropriate in the mortgage, they do have a right of rescission. And next slide, please, John. And John, if you have any questions about what I'm saying or want to add something, feel free to jump in.
No, don't worry. You couldn't stop me. Go ahead.
Okay. Wild horses couldn't stop you. And again, this is similar to what we were seeing with the MLS regulation, making sure that a potential buyer understands that the person they're signing a contract with doesn't yet have legal title to the property. So making sure that they know what's going on, they'd also have this 3-day right of rescission. Okay, next slide, please. Penalties. These are some of the penalties for what would be involved. One thing that I did not mention that I think I probably did not include in the slide is one of the proposals, part of this legislation is to require wholesalers to be licensed as real estate brokers. And
Yeah.
I know I left the biggest one out of the slides.
That was a big one. Yeah, I'm
That
surprised.
was
I
a
was going to
big
ask that
one.
question. I'm like, but yeah, that's huge because right now
That
they're not
was a big
required to be
one.
licensed, right?
Right. Some states have actually, some states have licensed wholesalers, just regular real estate brokers licenses, or salesperson's licenses. Other states, and Connecticut is one of those, has created a separate track, a separate wholesaling license or registration. And this will go into effect, I believe it's July 1st of this year. It's either June or July 1st of this year. In Rhode Island, part of why we looked at that was we initially approached the Department of Business Regulation earlier this year to say, hey, when the wholesaler is marketing this property, they don't own it yet, they have equitable interest, but they're marketing it, and then they're doing this markup. So is anything like that what a real estate broker does? Is this a commission? Is this a profit? What is this? Should there be a little bit more regulation about what's going on? Because often some of the wholesalers, not all, but some have as a business model you can find on any website that they're trying to target distressed sellers. There's nothing wrong with doing that. If you can pick up a profit or anything like that, spot a business opportunity, but everyone has to know what's going on. So that brings us to the penalties. The penalties for first offense, minimum $500 fine, minimum $1,000 fine for additional offenses. And then this final penalty is if a wholesaler is taking a profit on something and they're not either properly licensed or they haven't complied with these disclosures to the buyer or seller, they could be required to pay 3 times what that profit, up to 3 times what that profit is, as a penalty. So there's some hefty fines. The purpose is not to put wholesalers out of business, but just to make sure that consumers understand what's going on. And then that'll get us back to our questions. A lot of questions, I think, are related to both the legislation and the MLS rules. So,
Oh,
that's
yeah.
the
The
effective
proposed
date would
effective
be,
date. Now, again, this is the legislation effective date, not the
yes.
MLS rules effective date. Uh,
The MLS
and
rules, John, I think you mentioned before, were you mentioning before, we're waiting on a vendor to kind of finish?
yeah, we are. So, yes, yeah. So we have to get, you saw the yes no disclosure field. That's pretty much good to go. We're really waiting on the form, the supplement type, and the privacy setting along with that to just be finished. So,
Mhm.
hopefully not long. So I'm gonna why don't we you want to look at the Q&A, and I'm gonna try to
Sure.
multitask and drop the PDF of this presentation into the chat. Um,
Okay. Yeah, so let's see, I think we did this one. One suggestion that we had from someone was we were talking about dates and how there could be delays in some of these closings. The person suggested, can you use time is of the essence to keep dates on target. Absolutely. It's a very good suggestion. Just keep in mind if you use time is of the essence for, say, a closing date, that means that, 1 day, 1 hour too late is too late. So you just want to make sure that you're using extensions if needed. But yep, you can absolutely make the dates times of the essence. When John asked me to speculate about why we call it wholesaling, one of our listeners today said wholesale versus retail price. Yep, that's probably a better explanation than I was fishing at. And yep, that makes sense. Okay. Then we have, I think it's important to reiterate that assigning the contract does not negate anything in the contract, and it should never be assumed that there will be extensions. The burden is on the wholesaler to make sure to meet all the conditions of the contract if they want to assign it for a fee. Yes, that's correct, and that's a very good point. There's no one should ever assume in any contract that there's someone else, the other party will grant an extension. I think the issue sometimes that we see, and again, we're not trying to just single out wholesalers. This can happen with any other with other kinds of purchasers. Um, but at some point, if a seller, the one who has legal title to the property, they're under contract, and you've probably seen this with other transactions. You get someone under contract, the buyer needs an extension. Do they say no and start from scratch with someone else? Do they give an extension? Maybe that's time is of the essence or not. Where do you go? And then how far do you have that sunk time where you're thinking like, well, they just need one more week, and maybe I'll just give them one more week versus starting all over again. So I think that that is really the dilemma, that no one should ever assume that there'll be an extension granted.
Let me
Um,
read the next few, Monica.
sure, Don,
Give
thank
you a
you.
chance to get some water and rest your
And
voice a little bit.
save everyone's ears from my
Of
croaking.
course, they're
So
going to be ones for you to answer, but they're because they're all related to sort of the seller disclosures. First, shouldn't there be a seller disclosure from each seller? The seller number two would have a blank disclosure because they never lived there. I mean, I don't know. I mean, I think what we determined was that it's legally the obligation of seller number one. I guess doesn't preclude seller number two from providing one if they want to, but it doesn't what absolve isn't the right word. You're the legal schmiegel, but it doesn't release the seller number one of their obligation to also provide one, right?
yeah, I think the key to it is the timing of the closing. So if you're with something like an assignment, there's only one closing. So that's where the legal title owner would be the one who's providing the sales disclosure. They've already given it to the buyer. The buyer slash seller number two would then, they need to pass that on to the person to whom they're assigning their interests. If you've got two closings, so the builder who's buying land, and then they're completing their purchase before they sell new construction to somebody else, for example. Then yeah, normally now new construction, like I said, is exempt from a sales disclosure. But if we're a different type of seller with a flipper, let's say, that they're actually going to close on the property from the legal owner. They're looking for a buyer up in advance. They're going to do some work on the property before they actually close. In that case, there are two closings. Yes, the flipper would be required to provide a sales disclosure. They are not exempt from the sales disclosure requirement, although I do get questions about that sometimes.
Um, is there? I don't know the answer to this. There is no disclosure in a foreclosure. Is that correct?
Correct. Yep. There's a
It
list of
also rhymes.
exemptions. Yeah, there are a list of exemptions from the sales disclosure law. That is one of them.
Uh, a lot of wholesalers do not list on the MLS, so this form would not apply. Correct? Right? Yeah. I mean, that's the reality. Is a lot of them don't. And
Correct.
so, and it's likely they wouldn't meet the threshold to submit under these new rules because, I mean, I suppose it's possible, but this form probably won't even be on their radar. But if they're not listing in the MLS, that's correct. So, um,
Right. And that's
uh,
why on a separate track, the Realtor Association has filed legislation. I don't have the bill numbers yet, but they have been filed with Legislative Council. And so the bill numbers will be popping out sometime, probably in the next couple of weeks.
and so
Um,
to that point, one of the things that sort of issues raised here is so the wholesaler can market and make claims about the house property that the title holder will be responsible for. Question mark. i.e., the lot next door will never be developed. A year later, after closing, a building goes up next door. I mean, that's sort of a misrepresentation. I guess if the wholesaler isn't licensed, right, then there's still maybe some recourse, I guess. I don't know. I mean, legally, can they just misrepresent facts? I don't know, Monica. I'm
No,
answering. You
because
should be answering.
no, like any seller, separate from wholesalers, foreclosures, anything like that, any seller cannot make represent misrepresentations about the property, or they can be sued. So if I'm given wrong information, saying like, oh, this roof is brand new, or nothing will ever be built next door, or this is where the boundary is, or something, where the borders are, anything like that, I can be held to account as a seller. Just depends how much someone wants to spend on litigation, which is not fun. Anyway,
Here's a question. If seller one agrees to the showings, does listing agent one have to accompany? That's an interesting thought. It's not addressed in the
hmm.
form, right? It's really the marketing efforts of listing office two, right? But the seller may want listing. That's a great question. I don't know the answer. What do we?
Yeah.
Do they have to? There's nothing that requires them to be there, at least under MLS rules. But I don't know. Uh, I suppose. Again, here I am, the not lawyer, so I'm just pontificating here. But if, as previously discussed, the seller is responsible for perhaps misrepresentations made by a wholesaler in this example, it might behoove the listing broker number one be there during the showings, right? Because they are representing the seller one, right? So they have a duty to that seller to protect them, maybe. I don't know. What do you think?
I think that is a great question as well, and don't know if I have the best answer to it yet. So,
It may be something, this form maybe needs to be tweaked to address those things. It's a conversation to have if you're listing broker number one and because my guess is going to be that the seller, if presented with this form, is going to want to consult with the listing broker, anyway, right? Or maybe if not with their attorney, maybe at that point, right? Because you're
mhm.
at PNS, so they're going to need to discuss with an attorney. Uh, uh, so, and evaluate all of those things. So that's one of the things to add to the list of questions to discuss, I suppose. Does the seller want you to be there for those?
Right, exactly. We did have one comment. I'm jumping ahead. I know you're trying to take it
Yeah.
in order, but there's one that I feel compelled to mention. Someone has posted, wholesalers have helped many homeowners get out of bad situations. Be kind to them.
Yeah.
So no
Yeah.
one's trying to attack wholesalers as a business model. The idea is that, and I'm sorry if you're taking that away from that. I think the issue is, should everyone understand what's going on? If I'm a homeowner, someone comes to me, and I think of this with some of the foreclosure rescues that we saw a number of years ago during the recession. If someone comes to me and they say, "Hey, I see you're in trouble," because they looked up my mortgage and how much I owe and everything like that, and they offer me cash to help me get out of the situation. Yeah, if it's below market value, but I'm willing to take it anyway, just because someone has an immediate solution to my problem. Yeah, that's a perfectly legal, viable business model. Just like if someone who's a flipper, sees a good idea, sees a property that could use some work, they buy it and they fix it up and sell it at a profit. There's nothing wrong with people earning a profit. What's wrong is that people not understanding what's going on. And by what's going on, I'm not saying the actual new price that's being listed at, but just not understanding that, like, why is someone else listing my property? Why are there two listings for it? Who's this person who's showing up at the closing I've never heard of before?
Yeah.
Why is my short closing? Why does the buyer keep asking for delays when I thought they could pay cash? Those are the kind of issues you're trying to tackle, combination of MLS rules and legislation.
And just to make this point, because I think we're at time, uh,
Yes.
these rules only apply on MLS. That's correct. If the transaction is off market or off MLS, does the flipper need that seller's disclosure to assign the contract? I assume you mean the equity listing form, and the answer is no. That equity listing form is simply a form to get the property in MLS. It's not a form that you would use outside of MLS. And I think I saw a question earlier as well, is if somebody is listing an equity listing, and they don't want to put it in the MLS, do they have to submit a non-MLS? The answer is no, because they can't put it on MLS unless they have the equity listing form signed. So without that proper authorization, it couldn't be listed in the MLS anyway. So you're not obligated to do a non-MLS for these. Uh,
John, I have a suggestion for us.
you
So, like as you
do.
said, I do.
Oh, sorry, too bad, Monica. We're out of time. Got to go.
Uh, that's the issue. Well, I want to thank everyone for joining us. There's still some questions we haven't gotten to. So what I'd say is if you need to go, feel free to go. This is being recorded, so if you really want to listen to us hacking away answering a few more questions, we can do that. It'll be on the recording. So do you want to
Yeah,
try and plow through a few more questions,
yeah,
John?
sure. Yeah, that's fine. Let's do it. Uh,
Oh, and there was one about fines you might want to answer really quickly before everyone
well,
before
I did
we
drop, by the way, because I see there's a question about the PDF. I did drop that in the chat. Did you see that in the chat, Monica? Did everyone get that?
I see it, yes. We might
Yeah,
want to have that sent out with the recording
yeah, we can send that out with the recording as
to
well.
people. Yes.
So
And does that mention, and then the question was about what would the fines, the MLS fines be?
yeah, so I don't, I think it's whatever the standard fine. I don't know. Honestly, I should have had that. I don't know what the fine is. There are no new fines, so it would fall under probably some existing catch-all fine amount that we have currently. Um,
Yes.
but we can look at, adding new penalties if needed. We try to, we'd like to resort to fines as a last resort. Hope that, but
Mhm.
we're also, realists. So we'll address that if we need to at some future point. Uh,
Yes.
okay.
Oh,
So somebody said, weren't we supposed to discuss new construction? So at the very beginning, we talked a bit about new construction and the flipping, but do you want to talk about, I saw a couple of questions about that. Like, how does this apply to new construction? So I think, uh, it, uh, maybe it's not as common here as it is in Massachusetts, right? But there are oftentimes, uh, where a builder does not own the land yet, right? They're purchasing the land
right.
and then they're listing their development, but they want to sell off some of the new construction to help fund the land or whatever it is. So I don't know that it's how common that is in Rhode Island. Maybe it's not as common, but that would be an example of a situation where the builder technically would have an equitable title and not legal title to the land that is included with the new construction purchase. Now, maybe in some cases they don't sell it as a package and the buyer buys the land separately from the new construction. I don't know. You folks are the experts, not me. You know better than I do. But that's where how we've when we talked about new construction, that's sort of what we've contemplated. Uh,
And John, one person posted that he couldn't see the PDF. So we'll have this sent out with the webinar for anyone
I
who
can I
wants
can
to
drop it
use.
again too. Let me just try dropping it one more time in the chat. Uh,
Yeah, it was actually dropped if you've been checking the Q&A, it was
One,
dropped in the
two,
chat.
three. Boom. There it is. I just dropped it in the chat. So you should now, if you don't have the chat box, I don't think I can drop it in Q&A now. So it's
Yeah,
in
I don't know
there.
if you can.
But if not, like you said, we'll send it out with the
Okay.
link to the video.
So John, I've got one for you.
Oh, nice.
Yes, you ready?
Sure.
Is this definitely moving forward? Can we presume that there will be another of these Zoom meetings soon to clarify more? This may be imperative with some real estate professionals who are already in the news for their behavior.
Well, I mean, these rules are approved. We just need to do the system changes, but we can do another one of these webinars. Again, we're not creating some new business model here at MLS,
Right.
right? We're not promoting doing business this way. These things are, oh, the chat's disabled, so can't,
Ah, okay.
sorry about that. Oh, crumbs. Anyway, we're not, this isn't a marketing, a webinar saying, hey, here's a great new thing you should try to do. These are things that have existed out there already. Right. And
Mhm.
and in some cases, listings have been appearing in the MLS rarely, but and again, as I mentioned earlier, sort of in the flip scenarios or maybe new construction where technically the seller didn't have legal title. And so they were saying, I'm putting it in subject to seller taking title. And so they were sort of doing the flip and getting a head start. And, all these things are legitimate. And so what we want as MLS is to be able to provide you with access to what is going on in the marketplace while not necessarily exposing you or consumers to um, risk. And that's where, so that the only change here really isn't that, we're creating this new way of doing business or any of that. It's just that we're clarifying what can be listed in the MLS and how those things can appear in the MLS. So that's not just a free for all where these things are just showing up and it's like, well, wait a minute, this thing, the owner, the seller isn't even the title holder or whatever. So we're just putting some bumper guards, rails, what a bumper rails. I don't know what the expression is. We're putting some guidelines in there for listing these types of listings. We'll cut that out of the video. Hopefully, I'm just rambling now. Go ahead.
Our bloopers reel. No, that's okay. Should we just take these in order? What's left, and then I
Yeah,
know at
sure.
some point. I know we don't want to keep everyone till 11 who's still
Well, they
hanging
don't
out.
have to stay. I mean, again, you said they could leave, but I'd say let's do a hard stop at 10:40. How's that sound?
We'll give it a shot. Okay, lightning round. We had a comment
But
from someone early on who said the contract stays with the property until closing. Yes, that is correct in the case of an assignment or anything. Yep. Um, okay, can you provide? Okay, I think I already did that one. One thing I do see a theme of a couple of the posts here um, that they'd like to see us do like kind of a cheat sheet with spelling out some of these examples. So like what's an example of new construction? What would that look like? So I mean, I can certainly work with you on something like that if you want to have us do something like that. You're really just talking
sure.
about a couple of one-liners. Just I know we're given a lot of information in a short period of time, and particularly if you haven't taken one of these listings yourself or haven't shown a buyer one, I know it's can be a lot to
I
digest.
mean, I guess the situation is sort of, I mean, you folks are out there in the field, but I guess, sort of turning it back around as the professional licensees out there, have you ever come into a circumstance where you've been approached by somebody who is not the title holder of the property to market that property? And if the answer is no,
Mhm.
well, if you've not come across this, but if the answer is yes, then, and they want it listed in the MLS, then these are the things you would need to do. But it may just be, as I mentioned earlier as well, that this is something that just never shows up, comes up on your radar. It's just not anything that is a situation for you. But at least on the buy side, if you're working with buyers, you'll now be aware of, you'll know what to look for in the listing, right? And with that equitable assignment, yes, no field, and the disclosure in the remarks.
Mhm.
It's likely that, again, we've created these rules. It's very likely that there will be, I mean, we haven't had many of these in the first place. It's very likely that we won't have very many moving forward. So
I think there are a lot of good. I'm going to just summarize because we're getting close to our hard stop. One area that we haven't really gotten into, but I see in some of the questions and comments is the role of the listing broker. So if I'm the listing broker for seller number one, and let's say an unrepresented buyer comes to me and I get the purchase and sales agreement. So let's say I'm the only broker involved with it. Well, what if that buyer then comes to me as the listing broker and says, "Hey, can you list this for me in multiple listing service or can you market this for me?" Well, the thing is, here's the issue. And this is what some of you are getting at in the comments, if I know that this buyer is going to mark up the property for significantly more than the purchase and sales agreement, and I'm still representing the first seller, what kind of conflict of interest does that create for me? Even having them sign the MLS forms, I don't know, that really negates it for me because I'm aware at that point, whose interests am I really serving? Some people have commented about lawsuits in different states, investigations in different states. Not a big part of that is the issue. What is the role of the broker in this? Who is their loyalty towards seller number one or seller number two? What are they? So that's
well,
another area.
here's another thing as well, and I don't know the answer to this, but we're also assuming that there's always a listing broker one and a listing number one, right? Isn't it possible that these individuals are approaching homeowners that haven't had their property listed. They're just distressed, or they have identified targets of people who might be likely to sell, and so
Yes.
they're approaching the homeowner directly with a buyer, and then selling it.
Yep.
That may even be more common than a scenario where the listing was listed. Now some because anybody again, you folks are out there, not me, but in my mind, if the property's been marketed through MLS at, whatever the price is, and then somebody comes with a buyer and then they want to list it again at a higher price, it's, people are going to be able to see the history. It doesn't seem as likely as a scenario where the property was just never listed and the wholesaler goes home to the homeowner directly. So,
Absolutely.
in which case there's no listing broker one, but the seller still has, I guess, that they are a seller and has that obligation to disclose, but they really don't have anybody in their corner, right?
Right.
Other,
Well, I think on that note, I think, and we know we're sorry we didn't get to everyone's questions. We tried to summarize what was left. We'll go through those because I think there's some really good suggestions there. We really appreciate all of you joining us, especially those of you who stuck in for a few extra minutes after the end time. But really appreciate your joining us. And if you do have questions or suggestions, feel free to reach out to John on the MLS piece of it. Any legal questions or questions about the legislation, feel free to contact me or contact either one of us and we'll send you to the right person for answers. But we
right.
thank you very much and really appreciate your joining us.
Thank you, everybody. Have a good day.
Okay.